Greetings, my fellow free lovers of sovereign thinkers. This is LL3's newest podcast. My name is Craig, transmitting from the beautiful Beehive State, which is known as Utah. And today's date, Thursday, September 3rd, 2015. Yeah, I'm going to be focusing mostly on one subject today, which it's been looking at the hashtags on Facebook and Twitter and people manifesting and thriving and the pros and cons, and the left-right paradigm is really going out of whack over this thing, which respectfully can be a huge distraction based on the overabundance of exploitation. And I'm talking about Rowan County Clerk Kim Davis' case, which is occurred in Ashland, Kentucky. So I'm gonna give you my intake and look at some of the facts, and you can make a decision for yourselves. The only thing I'm gonna be reading from here is by Kentucky.com, which is entitled "Judge Jails Rowan Clerk for Contempt. 5 deputies pledged to issue marriage licenses Friday morning." And this is done by John Seves, if I'm correct. So let me just verify that. It is John Seves. Let's find out. Yep, John Chavez, excuse me. So, as it reads here, a federal judge sent Rowan County Clerk Kim Davis to jail Thursday for contempt of court after she testified that her religious beliefs against same-sex marriage made it impossible for her to comply with this order to resume issuing marriage licenses. "My conscience will not allow me," Davis told U.S. District Judge David Bunning in a quiet voice. Davis, an apostolic Christian, has refused to issue any marriage licenses in Rowan County since the U.S. Supreme Court legalized same-sex marriage in June. So that's usually what I was informed and what I briefly read. It's based on the First and 14th Amendments of the U.S. Constitution, but I will continue on here. After U.S. Marshals took Davis into custody, where she is expected to remain until she agrees to comply with Bunning's order. The judge ordered her 6 deputy clerks to stand and tell him if they will comply with this order to issue marriage licenses, at the risk of facing their own contempt penalties. All but one of the deputies, Nathan Davis, Kim Davis' son, said they would obey the judge, some more reluctantly than others. "I'm a preacher's daughter," Deputy Clerk Melissa Thompson told the judge, crying. "It is the hardest thing I have ever done to do in my life." Bunning said he would not hold younger Davis in contempt, since the rest of his colleagues are willing to obey the law. So on Friday, the Rowan County Clerk's office is set to open without its clerk, for the first time recognized Supreme Court's landmark gay marriage decision. At least 2 of the couples suing Davis for a marriage license said they plan to be at the county courthouse early Friday to apply yet again, with the expectation of success this time. "It was sad in a way that Miss Davis decided she wants to stay in jail," said Jody Fernandez, one of the plaintiffs who was engaged to marry Kevin Holloway. "I never wanted her to be going to jail, but that was her choice today." Outside the courthouse, Roger Gammon, one of Davis's lawyers, called the clerk's jailing unprecedented in American law. Davis's legal term indicated that immediately planned to appeal Bunning's civil contempt finding. Today, for the first time in American history, American citizen has been incarcerated for having a belief in conscience that a marriage is a union of one man and one woman, Gammon said. The judge rejected such arguments during the day-long set of hearings. Bunning said she has he has his own religious beliefs as a Catholic, and Kim Davis is welcome to hers. But she cannot, as a public servant, put her religious beliefs above a Supreme Court decision and his preliminary injunction of August 12th, ordering her to resume issuing marriage licenses, Bunning said. Following Davis's logic, Bunning said a Catholic county clerk could refuse to give a marriage license to a divorce applicant without proof that the previous marriage was not annulled, as church doctrine requires. Davis, who has said repeatedly she will not resign her elected office, appealed the preliminary injunction to the Sixth Circuit U.S. Court of Appeals, the Supreme Court, but both of which flatly denied her, Bunning noted. By continuing to flout the order this week after running out of appeals, Davis crossed a line, he said. The court doesn't do this lightly, ma'am, Bunning told Davis as he found her in contempt. You don't strike me as someone who is contentious or combative. In this country, we live in a society of laws. Our system of justice requires citizens and significantly elected officials to follow the rules of the court. Rules of the courts. Okay? Later in the day, after Bunning established that 5 Davis's deputy clerks were willing to issue marriage licenses, Davis' lawyer asked the judge to reconsider sending her to jail. If the people of Rowan County can't get a marriage license from the clerk's office, even if it's over Davis's objections, then surely the judge's orders to satisfy, the lawyer said. But Davis scotched that effort by informing Bunning from a courthouse holding cell that she would not agree to let her deputies obey the judge's order if she is released. With a shrug, Bunning said Davis would remain incarcerated for at least a week until she can review how her office operates in her absence. She was taken to the Carter County Jail, but can free herself by agreeing to comply with this order, Bunning said. Turning back to the deputy clerks, Bunning warned them that he would be unhappy if he learned of shenanigans at the clerk's office, like more refusals of service, or a sign on the door Friday saying, closed for computer repairs. I do not expect compliance, the judge told the deputy clerks. The Rowan County couple suing Davis asked Bunning on Wednesday to find her in contempt. Although they recommended he levied stiff fines against her, as opposed to incarcerated her. Bunning rejected the possibility of fines Thursday after Davis testified that Liberty Counsel, the religious advocacy group, provided her with lawyers, was collecting money on her behalf from her supporters nationally. Additionally, Davis and her lawyers insisted that fines will not compel her to obey the court order, which is supposed to be the point of contempt penalty. This case is not about money at all, Jonathan Chrisman, one of Davis's lawyers, told the judge. She has no amount of money in her conscience's bank account that will cover the cost to her if she had issued one of these licenses. Davis's lawyer, whether a Rowan County marriage license issued without Davis's authorization would be valid, but other lawyers in the courtroom, including Rowan County Attorney Cecil Watkins, said deputy clerks could issue marriage licenses too. Davis, a Democrat, began a 4-year term as a county clerk in January. She can be removed from office by impeachment in the Kentucky General Assembly, which seems unlikely given the vocal support she has received from lawmakers. Senate President Robert Stivers, Republican Manchester, filed a friend of the court motion late Wednesday in Davis's defense. Stivers asked Bunning not to find the clerk in contempt until the legislature could meet and rewrite marriage laws in a way that protected the religious liberties of county clerks. Lawyers for Stivers and Democratic Governor Stephen Beshear were in the courtroom Thursday. Davis is suing Beshear over a letter he sent to all 120 county clerks in June, instructing them to comply with the Supreme Court's same-sex marriage decision. That part of the increasing complex of litigation around Davis, with at least 3 lawsuits at this point, has remained on hold while Bunning sorted out enforcement of his preliminary injunction. So this is pretty interesting. Someone gets arrested for refusing to have of issuing a marriage license to a same-sex couple. The federal judge with the U.S. Marshals went to a state on making this happen. This is pretty baffling, I will say, out of respect. And I'm not a person that's going to condemn people for marriages of the same sex, as long as they're consensual adults. So I'm not going to go into that. Like, I'm not here to condemn them whatsoever. I have my views, but it's not being conscripted or bashing or anything like that, because I do things, everything I address is in good faith. But I have to look at this one way, as a 10th Amendment issue. In that part for the time being. And I'll just read the 10th Amendment to you, which is from findlaw.com, and it says here, the power not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So, and this is really interesting because, and they can tell you here on the 10th Amendment, annotations, reserved powers, and we'll just see what that means on there. On reserved powers, on annotations of reserved powers from findlaw.com. And it says here, it says pretty long. And like I said, the 10th is like, I'll just say right here, the 10th Amendment was intended to confirm the understanding of the people at the time of the Constitution was adopted that powers not granted to the United States were reserved to the states or to the people. It added nothing to the instrument as originally ratified. The amendment states but a truism that is all retained, which has not been surrendered. There is nothing in the history of its adoption to suggest it was more than declaratory of the relationship between national and state governments as has been established by the Constitution before the amendment of its, or that is purpose other than allay fears that the new national government might seek exercise powers not granted, and that the states may not be able to exercise their federal power, reserve powers. That's how I'm going to go with that on this area. And there's like multiple cases on this. So I will just head back here, and we'll just check out something else in here from Defined Law, which you can look at yourself. Federal police powers. Okay. And like it says here, a year before collector or day was decided, the court held invalid except as applied in District of Columbia and other areas of which Congress has exclusive authority. A federal statute penalizing the sale of dangerous illuminating oils. Okay, so it's more like, it says here, the court did not refer to the 10th Amendment. Instead, it asserted that express grant of power to regulate commerce among the states has always been understood as limited by terms. Well, I'm just going to make you that decision there, judge for yourself. But one thing is interesting here, you could look at Federalist Papers 46, and like it says here, but adventurous encroachments of the federal government on the authority of the state government would not excite the opposition of a single state or a few states only. There would be signals of general alarm. Every government would espouse the common cause. A correspondence would be open. Paths of resistance would be concerted. One spirit would animate in the conduct of a whole. Same combinations, in short, would result from an apprehension of the federal as it was produced by a dread of foreign yoke, unless the projected innovation should be voluntarily renounced. And it's more like encroachments, how the federal government can encroach on the states. And I can continue on here. The same appeal of a trial of force would be made in one case was made by the other. But what a degree of madness could ever drive the federal government to such an extremity? In the contest with Great Britain, one part of the empire was employed against the other. The most numerous parts invaded the rights of less numerous parts. The attempt was unjust and unwise, but it was not in speculation, absolutely criminal. But would it be a contest of the case we are supposing? So there's some questions on there. But when you look at that, it is the federal government, according to the 46 Federalist Papers 46. It talks about the balance of power. Okay, that the federal government, is areas in the federal government should not encroach on states' jurisdiction. And a very good example of the case was Sheriff Prince and Mack versus the United States of America against the Brady Law. So I'm going to leave that on there as well. That was published by James Madison Tuesday, January 29, 1788, to the people of the state of New York. Something to really got to look at, okay, about federal law superseding state law, and so forth. That's the things you really have to question. And of course, we could look at, Section 1 of the Kentucky Constitution, which is Bill of Rights. And it's like it says here on Section 1, all men by nature free and equal and have certain inherited and inalienable rights, among which may be reckoned. Section 1, the right in enjoying and defending their lives and liberties. And we could hit 3rd, the right of seeking and pursuing their safety and happiness. And 4th, the right of freely communicating their thoughts and opinions. Alright, so we can hit those areas on there. And I'm going to add that to it on the Kentucky Constitution. So I'm going to definitely put that in there. And of course, when you keep on going down, all men are equal. Okay, it says right there as well about all men are equal. Like it says here, Section 3 of it goes, all men, when they form a social compact, are equal. No grant of exclusive, separate public elements or privilege shall be made to any man or set of men, except in consideration of public services. So that's one thing is right there. Is public services. So can Kim Davis violate that? It's possible. I could say it is possible according to this. So we could hit that one, and I hit Section 228 of the same Constitution, because a clerk of courts is usually appointed or elected. Okay, and it says here, officers and attorneys, members of the General Assembly, and all officers before they enter upon the execution of their duties in their respective offices, and all members of the bar before they enter upon the practice of their profession shall take the oath or affirmation, I do solemnly swear or affirm, as in the case may be, that I will support the Constitution of the United States and the Constitution of this Commonwealth, and be faithful and true to the Commonwealth of Kentucky, so as long I continue a citizen thereof, and that I will faithfully execute to the best of my ability in the office they're going to be of, according to the law, and I do further solemnly swear or affirm, since the adoption of the President Constitution, I, being a citizen of this state, have not fought a duel with deadly weapons within this state, nor out of it, nor I sent or accept a challenge to fight a duel with a deadly weapon, nor I have acted as second in carrying the challenge, nor aided or assisted any person thus offending. So help me God. So technically right there, she could breach her oath of office, because it does make sense on the state level. And there is, of course, the impeachment process on there. So it's been like a gridlock in the state of the Commonwealth of Kentucky about her actions. But this right here is technically she may have or done, allegedly, okay, breached her oath of office from that last sentence, nor aided or assisted any persons thus offending, so or challenging. And that's one thing people have to really look at. And of course, if you look at go to the site here, the County Kentucky Court of Justice, and there are a couple of documents in here, which is on a PDF format, one Supreme Court order and two Code of Conduct. And we could just hit one of those areas, which is not a big thing. And this is by Amendment to Administrative Procedures, Court of Justice, Part 16, Circuit Court of Clerks or Commission. And like I said, it's here in Section 1, actually pursuant to Sections 110, Sections 110, subsection 5B, and 116 of the Constitution of Kentucky, is hereby ordered that the Administrative Procedures of the Courts of Justice, Part 16, Circuit Court Clerks Conduct Commission is hereby amended as follows. And this is from the statement, Section 1 to be exact. It's like 9 pages long, but it will talk about Section 1. That would be the main focus. And like it says here, Circuit Court Clerk play a key role in the administration of justice by maintaining all official records to collecting fees, fines, and costs. Circuit Court Clerks perform a variety of duties prescribed by Kentucky's Constitution, statutes, rules, and administrative procedures that are integral to Court of Justice and operations. Therefore, it is essential that Circuit Court Clerks uphold high standards of integrity, impartiality, and independence in order to promote public confidence in the judicial system. So right there, it could be a key that Kim Davis was being partial based on her religious beliefs, because there's a religious freedom clause in a section in religious liberty section in their state constitution, just to give you guys that fact. And it said, we can keep on here in paragraph 2 of that. It goes, as elected officials, circuit court clerks are ultimately accountable to the voters in their counties for their conduct in office. However, pursuant to KRS 30A.010, circuit court clerks are also state officers who are subject to the administrative control of the Chief Justice. And it says, and we go here, and just hit the final paragraph here. It goes, these rules and the Circuit Court Clerks Conduct Commission created herein are intended to assist the Chief Justice in determining whether disciplinary action and or remedy measures against a Circuit Court Clerk for alleged official misconduct or otherwise improper conduct is warranted. These rules shall govern handling of complaints against Circuit Court Clerks alleged have engaged in such conduct. So something right there, because even with her oath, okay, if you sign your oath, after you do your oath of office, usually you have to sign a document that you're going to honor that. So based on the contempt charges, she breached her oath, and they don't have any recall votes according to the article I read, the newspaper article I read, and even I looked at the state constitution. It only works on an impeachment level, so it's pretty strange. Each state does things differently. Just to give you folks some pinpoints. Of course, they give you all the definitions on what this means, and this and that, and complaints. So, final disposition and investigation. And of course, commission and all that. But it's very, like I said, it's the states should have probably would have handled it a little bit better, but have a federal court, have a federal government involved. I find that pretty odd, okay, and that's why I had to use the 10th Amendment and of course Federalist Papers 46 by James Madison. So I'm going to add everything on here in my footnotes for this episode, so at least you can read it yourselves. And about general provisions, okay, and all that good stuff. So it's something to really got to think about. And this is done that was signed by John Termero. Okay, that's on the 28th day of July 2014. So I'm going to be putting this down, and we're going to hit one on Code of Conduct. I think this one here get people thinking too. Supreme Court of Kentucky order, Code of Conduct for Circuit Court Clerks. And it goes right here, statement of purpose and applicability. It says here, circuit clerk plays a key role in the administration of justice, from maintaining official records, collecting fees, fines, and costs. Circuit court clerks perform a variety of duties prescribed by the Kentucky's Constitution, statutes, rules, and administrative procedures that's integral of the court of justice operations. Therefore, it is essential that circuit court clerks uphold high standards of integrity, impartiality, and independence in their personal and professional affairs in order to promote public confidence in the judicial system. Circuit court clerks shall diligently perform their duties and avoid situations that might lead to conflict, the appearance of conflict, or the appearance of propriety between self-interest and their duty to the courts and general public. And we can just go a little bit further down here on the compliance statute with the rules. All clerks shall comply with the Constitution of Kentucky, Kentucky revised statutes, Kentucky Supreme Court rules, including Kentucky rules on criminal and civil and criminal procedures, applicable proportions of the administrative procedures of the Court of Justice, Part 3, the lawful directives of the Chief Justice of the Supreme Court of Kentucky and the local judiciary, and orders of the Supreme Court and the local judiciary. And if I'm seeing here is that confidential information. Section 4 is interesting, so I'm definitely might have to look at that one. Okay, and I'm just like browsing through here. Oh yeah, we'll just hit section. We'll just hit section 4, and we'll just go here. Subsection 2: Circuit court clerk shall perform their duties impartially. A. With courtesy and respect for the public, litigants, lawyers, subordinate employees, and all others with whom the clerk interacts as part of his or her official duties. And B, subsection B, without bias or prejudice shown by words or conduct based upon race, national origin, color, religion, sex, sexual orientation, age, disability, genetic information, smoker or non-smoker status, veteran status, or political affiliation. So, based on this Code of Conduct, a latest edition, Kim Davis have you could say in good faith, allegedly, or actually dishonored it. That is the thing with the whole license issues, because based on that Code of Conduct, she was in there for contempt. But in my personal view, it should have never, ever went on a federal level. Okay, based on the 10th Amendment and Federalist Papers 46. Should have never went that far. She have made discredit herself on her oath of office under the state constitution and so forth, and the Code of Conduct. But like I said before, on a federal level, getting arrested, I have to disagree with that aspect. So it is like a double-edged sword. Okay, why have it on have the feds come in and arrest her for contempt, which on the state level she already done that, and that should have been handled in the Commonwealth of Kentucky. This is what I have to really observe. It doesn't matter what your creed is. I'm just giving you all the facts and my views to the best of my ability. I don't care what the ACLU has to say or the religious right. It don't mean anything right now. I'm just trying to make it right there, fair, thorough, and learning this as well, and sharing it with my fellow audience who are freedom loving, sovereign thinking individuals, regardless of your race, color, creed, gender, sexual orientation, etc. This is why that should have been handled, or not. I would have waited for the next election to vote her out. Then you have some merit. But based on a federal level, I have to disagree. It shouldn't be the federal government's problem. It should have been the bluegrass states' affairs, and should have been in that area, period. So this is how I examine these areas. And I had to scratch my head. But I like to thank my colleagues, told me about her not honoring her obligations, which is legit. I'm not going to argue about it, get a little bit more thorough. So I just hear all the debacle and fiasco. But here's the thing, I'm pretty disturbed, even with the Supreme Court decision. And I know a few others, like Gary Franchi from Net News Network, and I have to agree with them on this. You can't legislate love. So everyone in the LGBT community, not everyone, but the great so-called leaders or organizers, went to the U.S. Supreme Court and told the federal government, we want a license to get married. It's like saying, I want this to be a privilege. And that's when I chat with people, they're so happy, oh yeah, the gay marriage and all that. But how the direction it went is a slap in the face to every single one of us citizens. We've all been swindled one way or the other. But a license is not a right, but a privilege. And I got a couple of definitions from the lawdictionary.org, Black's Laws Dictionary, originally. And I will give you this definition of what license means. And it says here, in the law of contracts, a permission accorded by a competent authority conferring the right to do some act which without such authorization would be illegal or would be a trespass or tort. Okay, so that's a big list of others, but on that permission, you want to have permission to get married? According to the 9th Amendment of the U.S. Constitution, those rights are natural born. They're enumerated. Why have to request some competent authority that you want to get married on a consensual adult basis? Something to think about there, my friends. Really, you have to question that. Alright, this is why I just have to scratch my head, and I can't blame Gary Franchi on this, and even myself, when people were talking about Facebook, oh, this is a great day, and people were in tears, and I'm like saying, oh my goodness, you have to look at the fine print. Yeah, they use First and 14th Amendments of the U.S. Constitution. Yeah, it says all well and good, but the fine print about a marriage license, any license, like a driver's license, a concealed weapons permit license, you have to have permission because they believe you are not competent of legislating your own way of loving one another. That's why I tell people laws cannot do that. And I'll be very sincere. Like I said, in my personal view, in good faith, yeah, marriage could be between a man and a woman, but that's just my view. But I can't conscript or preach that to others. However, every individual has that right to make those certain decisions without harming others. That's when I still just puzzled. That would be the great word to use. On the other hand, like I said, not here to condemn anyone, regardless of your sexual orientation. But something to think, like I said, something to think about. And here's another one too, another definition. What is marriage license? As it says here, the document that's executed by the public authority that gives the couple permission to marry. Not a right, a privilege. This is why I always have to let you folks think a lot thoroughly. It's okay to be critical in these areas, but do it in good faith, like myself is addressing to all of you listeners out there. I don't believe in that marriage licenses. Alright, maybe some sort of certificate of agreement. That would be better. Why have the state do that? Why? So they can collect taxes from you? They could tell you, well, you know, like only family members, and if your person, your companions, is in the hospital, only family members can do that because the state said so. It's just, being a little sarcastic, but I'm just giving you guys examples. It's a privilege, permission, and this is why I was disappointed with those so-called leaders from those groups that went to Washington, D.C. and beseech to the state that we want permission to get married. And they should have never, ever been doing that, regardless if you believe in having a license to marry or not. It doesn't matter. It's a right, natural born right, not a privilege. And that's all I have to say. Thank you for listening to this episode. Plus, feel free to download and share this throughout your social media network. Plus, if you have any questions, comments, recommendations, compliments, criticisms, love letters, hate letters, don't matter. Or if you want to send me information that's be interesting, I recommend everyone use your views with decorum. You can hit me on Facebook, Twitter, Google+, Spreaker, iHeartRadio, or send your comments on YouTube. Or you can email me at lokiluck3@gmail.com. Once again, thanks for your time. Plus, always remember that demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves, keep on spreading the love, and may your guardian spirits be with you.